Hello and welcome to this presentation of the Common European Sales Law for the European Civil Law Observatory. My name is Dannemann and I'm a Professor of Law at the Center for British Studies at Berlin's Humboldt University. Today we'll be looking at three issues. What is the Common European Sales Law? What is the scope of the Common European Sales Law, the substantive scope? To which type of contracts does it apply? What kind of rules are covered? The personal scope, who are the parties who can use the Common European Sales Law? And the territorial scope, where can it be used? And finally, how can parties apply the Common European Sales Law to their contract? What is the Common European Sales Law? Currently, it's a draft regulation. The European Parliament and the European Council are discussing a proposal from the European Commission for a regulation which would establish a common European sales law. This CESL, as it is called for short, would be an optional European contract law. It only applies if the parties choose so. The purpose of the Common European Sales Law is to allow businesses to sell goods and related services across Europe under one legal regime and using one single sales platform, while at the same time providing a high level of consumer protection to the consumers. What are the starting points we're looking at? Why would one need such a Common European Sales Law? Well, presently, if businesses want to sell their goods or related services within the European Union, there will be a multitude of lawsuits taking place at different places where the consumers are being located. Whenever businesses are selling goods to consumers in different countries, that means that the principal place of jurisdiction will be in those countries. The consumers can choose to sue business at the business's place of residence, but only if they wish to do so. In combination with the jurisdiction issue, we have to look at choice of law. Normally, if businesses sell goods to other suppliers, they will have standard contract terms which will stipulate that there the seller's law applies to the contract. And this is also the regular case we're looking at. However, in consumer sales, it isn't just the seller's law which governs the contract. The consumer must not be deprived by a choice of law of the consumer protection rules which apply at the consumer's place. All this can be found in Article 6 of the Rome I regulation. So if we take this together from the seller's perspective, sellers who sell across Europe are exposed to 28 different jurisdictions as soon as they sell to consumers. And it also means that if they sell across Europe, they're exposed to 28 different regimes of consumer protection rules, because these are not fully harmonized within Europe. From the consumer's perspective, there's also something to be desired. While they can sue a seller in their own place, this will almost certainly, as soon as the seller uses a choice of law clause, involve the application of a foreign law. So a consumer will have to get legal advice, plead and prove a foreign law, very frequently when seeking redress against the seller. What would change now if a common European sales law was adopted? The seller would remain exposed to litigation in 28 different countries for business-to-consumer sales. However, the seller could make sure that the same legal rules apply, so that the seller would know in advance, without needing costly legal advice, what are the rules which will govern the contract. These would be the same throughout the European Union. And another advantage, the CESL rules do not just cover consumer sales, they have specific consumer protection rules which simply do not apply for business-to-business sales. So the same legal regime can also be used for business-to-business sales. From the consumer's perspective, one advantage would be that if a consumer seeks redress against a business, the consumer would no longer need to consider the application of a foreign law, thus saving time and expenses. The consumer would also enjoy a high level of consumer protection, in many cases higher than the consumer would enjoy without the Common European Sales Law. Let's now look at the substantive scope. What kind of contracts can be covered by the Common European Sales Law? Well, CESL can be used for contracts for the sale of goods, not real property, but goods. It can also be used for the sale of digital content. So these would be video files, audio files, software, ringtones, you name it. CESL would also cover the gratuitous supply of digital content, so contracts where the other party, consumer or otherwise, would not pay anything in return for the digital content. CESL should also be used for sales like, that's the wording that is currently being discussed, cloud computing services. That would be the storage of materials on the web to which the buyer would always have access from various places using various machines, as well as the supply of other services which are related to the sale of goods or the supply of digital content. As negotiations stand at the moment, it looks as if CESL will be limited to distance contracts. That was not in the original proposal of the Commission, but it looks rather likely that such a limitation will be imposed. What about the scope of rules which CESL can provide? Well, first there is a full set of pre-contractual information duties that is identical with the rules provided in the Consumer Rights Directive. There are rules on the conclusion of the contract, formation, what needs to be done for a contract to be formed, offer and acceptance, etc. There are rules on the rights of withdrawal for consumers, and these are again the same as in the Consumer Rights Directive. There are rules on what can be called deficiencies in consent, which would be rules on mistake, duress or undue influence, misrepresentation in the common law. All these are also covered by CESL rules. There are rules on interpretation of contracts. There are rules, these are quite important, on the control of unfair terms, non-negotiated, not individually negotiated terms. CESL has a general clause, a general unfairness test for business-to-consumer contracts, but also for business-to-business contracts. So there is an element of unfairness control in B2B contracts as well. But importantly, for consumer sales, CESL has a full set of black and grey lists. That means the blacklist contains such clauses which cannot be negotiated in business-to-consumer contracts at all. For instance, provisions which shift the burden of proof or which seek to limit the remedies, statutory rights of the consumer. There's also a so-called grey list. These are rules which require an element of balancing on the side of the court and when applying CESL, clauses which can be negotiated if they remain within what is reasonable. Also an extensive list of grey rules. There are rules on the rights and obligations of the parties, what the seller has to do, what the buyer has to do. There are also rules on the remedies for non-performance. These build on the Consumer Sales Directive but go beyond that and can be considered to contain some improvements on the Consumer Sales Directive. There are rules on restitution of performances which have been rendered under the contract in case of termination of the contract and avoidance of the contract, and there are rules on prescription of claims which arise under the contract. There are some gaps in CESL. CESL does not contain rules on pre-contractual obligations other than information duties. Some legal systems impose such pre-contractual duties, in particular a rule to negotiate in good faith, etc. There are no rules in CESL on that. There are no rules on illegality, what would make a contract illegal and what would be the consequences of such illegality. There are no rules on the transfer of rights and obligations, in particular assignment of claims under the contract. There are no rules on the recovery of mistaken overpayments and some other restitution cases. These could be covered by a generous interpretation of the existing rules on restitution after termination or avoidance, but there is no express coverage of these situations. All these rules should be provided by the contract law in accordance with Article 12 of the Rome I regulation. And because CESL does not supply these rules, there is actually no choice. One needs to couple CESL with a backup contract law, which ideally should also be chosen in the contract. One disadvantage of CESL. There are also some neighboring areas involved in the sale of goods across borders where CESL, as any other sales law, will interact with other laws when it comes to, in particular, the transfer of ownership in the goods. This is property law, and different conflicts will apply, usually the rules at the place where the goods are located. There is some overlay between sales law and unfair trade rules, unfair trade practices relating to the advertising and selling. There's also some interference between the control of unfair terms in CESL and collective redress procedures against the use of standard terms. As it stands, these procedures can take place in all of the European Union member states, and there is to date no way of coordinating such collective redress procedures, which could be taken up against one and the same clause in a CESL-governed contract for the sale of goods. As to the personal scope, CESL can be used for both business-to-consumer sales and business-to-business sales. There was some further restriction in the European Commission proposal, namely that CESL could only be used for B2B sales if one of the businesses was a small to medium enterprise. This has been dropped by the Legal Affairs Committee of the European Parliament. We'll have to see whether this change will eventually feature in the finished product. CESL cannot be used for consumer-to-consumer sales. So when consumers sell goods over the usual vending platforms, the application of the Common European Sales Law cannot be stipulated. There's also a bit of a grey area as to parties who are neither businesses nor consumers, as could be the case for charitable organizations. As matters stand, such parties can probably be buyers, although the CESL has no express provision on that. The present draft looks unlikely, though, as offering CESL for such non-businesses, non-consumers, selling their own goods and services under CESL. The wording of the present draft indicates rather clearly that this is not possible. Let's now look at the territorial scope. There's a requirement that at least one of the parties to the contract must be linked to a European Union member state. In the case of a business, this is pretty straightforward. The link is their place of residence, which is defined as being the central administration of the business, or where the contract relates to a branch office, the location of this branch office. If the business is a natural person, then the trading address of this natural person. So if these are located within the European Union, we need not even bother about where the consumer is being located. However, if a business is outside the European Union, then at least the consumer must be linked to the European Union. Such a link is provided by any of the following three addresses. First, the address which the consumer indicates to the business. This need not be the actual residence of the consumer. There is no further check, simply the address which the consumer indicates to be his or her address to the business. Alternatively, the billing address, or alternatively, the delivery address. Any of those three will link the contract to the European Union, regardless of whether the business has a link to the European Union. The Commission proposal contained a further restriction that CESL should only be applied to cross-border contracts, which would of course have made it very difficult to establish CESL as one legal regime where one business can sell to everybody under this regime on one platform. Whether this change by the Legal Affairs Committee will see the light of the day depends on whether this can be covered by the legal competence of the European Union to issue such a regulation. So we'll have to watch this space. Finally, how can CESL be chosen to apply to a contract? It's very straightforward for B2B contracts. A simple, regular choice of law will suffice. As mentioned, it should be coupled with a choice of a domestic sales law to cover those areas for which CESL does not provide any rules. It's a little more difficult for B2C contracts, contracts between businesses and consumer. First, the consumer must be supplied with what is called a standard information notice, which is contained presently in Appendix 2 to the draft regulation and goes by the handy acronym of SIN. Then the consumer must expressly choose CESL in a separate statement, one could argue in a separate agreement. So it's not good enough if there is just a mention of CESL somewhere in the contract. There must be a separate agreement by which the consumer agrees to use CESL. What if the standard information notice was not supplied before the conclusion, as would be difficult, for instance, in telephone sales? Well, then there is no choice of CESL unless and until the consumer has first received the SIN and then has expressly agreed to the choice of CESL. There is no way in which a business could set a period of grace to the consumer or in any way force such a declaration out of the consumer, which means there can be a period of prolonged legal uncertainty as to which law applies to the contract. Normally, not a good idea. So let's now look at the main pros and cons as concerns CESL. CESL's main advantage for cross-border sales are reduced transaction costs. Just imagine if you were a seller and you would have to inquire about 28 different consumer regimes which might apply to your contract, and you will realize this is a real cost saver. Another advantage is that both parties get their home law. CESL would be national law, an alternative set of contract law rules in all of the member states, so no one would have to trouble with a foreign law, not courts, not parties. And CESL would, for business-to-consumer contracts, avoid the present overlay between the chosen law of the seller and the buyer's consumer protection rules, which create an area of uncertainty. CESL's main disadvantages would be that there would be certainly an initial period without case law where courts in various states would have to find out what the CESL rules mean when applied to a particular case. This would take a few years. The Court of Justice of the European Union has the ultimate say, of course, on the interpretation and application of CESL. There are also some new problems which would not exist without CESL. These would be problems on the borderline between CESL and the domestic backup contract law, which needs to be chosen or which needs to be applied to cover where CESL contains gaps in the contract law. So how suitable would CESL be for cross-border for distance contracts? As matters stands, CESL rules are broadly suitable for distance contracts for the sale of goods, for the supply of digital content, for related service, and for sales like cloud computing contracts. So this is the main purpose of CESL. It looks as if, give or take a few criticisms here, CESL can do that job. CESL rules are particularly suitable for contracts for the gratuitous supply of digital content, where the alternative would be a choice of a common law-based contract, in particular English law. That's due to the fact that under English law, the English doctrine of consideration, if only one party promises to perform something and the other party does not, such contracts cannot be enforced, meaning that somebody distributing digital content gratuitously will find it very difficult, or at least risky, to distribute under such contracts, because it's not quite sure whether any limitation clauses would be effective because of the doctrine of consideration. So CESL is certainly an option for such contracts. CESL rules in their present form are, however, unsuitable for such contracts where the standard information notice cannot practically be supplied before the conclusion of the contract, as is in particular the case for telephone sales. So CESL is definitely not a good idea for such contracts. So that brings to an end what I had to say about the scope and the application of the future Common European Sales Law. Thank you for your attention.